Okay, let's bring in our guest for this hour. Joining us, criminal defense attorney and protege of Johnny Cochran, Tamara A. Walker, joining us this evening. Thank you so much for being with us, Tamara. So in Julia's report, you hear that we're kind of hearing different eyewitness testimony, which is really key for the state. And there's some discrepancies. You know, one person saying, I didn't see him, Chad Oulson, the alleged victim here, throw popcorn. One saying, I did. One saying, I saw him flick the popcorn. At the end of the day, flicking popcorn, that's not a reason to kill someone.
Absolutely, and thanks for having me. You know, anytime you have an event that's witnessed by numerous people, and I think in this case, if I read correctly, there's over 100 witnesses, you're gonna have slight variances. You know, obviously it's been 8 years, so you have people's memory to think about, and you also have, you know, people's different perspective, what they bring into it, how they remember a traumatic event. So all of those things can account for the small variances in testimony that you saw.
Yeah, so you mentioned a really good point there, the fact that it's been 8 years since this incident actually happened. So, you know, an unusually long time to wait for the trial to come to fruition. Does that have a negative impact on the state's case, or could it play to their favor?
Well, you know, typically a delay like that, in my experience with cases that I've had, it works to the favor of the defense. I'm not certain that that's going to happen in this case because, like you pointed out, you know, it is difficult to argue that you felt in reasonable fear for your life from popcorn. So I don't know how it's going to play out with this particular jury, but normally long delays help the defense.
Yeah, you know, speaking of the passage of time, we're looking at a defendant who's now aged and is about 78 years old. At the time of the incident, was 70 years old. And part of the argument of the defense has been, you know, he was up against a much younger man who was stronger, and essentially said, look, I'm too old to get into a fist fight and take a beating, so I'm going to pull out my gun if I feel threatened. Do you think that's a viable line of argument?
I think that it is problematic for the defense. Here's why. Number one, the movie previews were on and the man was texting. He wasn't on his phone. I think that's an important distinction because he initiated this whole situation. Number two, it seems as if the cell phone usage, texting or whatever it may have been, had ended at the time that this conflict escalated. So I think those are going to be two big issues for the defense. The bottom line is, you know, like my grandma used to say, if you can't finish it, don't start it. She didn't say it quite like that, but words to that effect, basically. You know, he very well could have just simply minded his business during the previews.
Yeah. How did you think that the defense did today in terms of their cross-examination? Because at times they were pretty aggressive and insinuated, actually, that one witness lied.
That's their job. That's exactly what they have to do. They have to pick out reasonable doubt wherever they can. And I would agree that the cross-examinations were rather aggressive, but you know, there is a skill and an art to cross-examination. It's one of my favorite parts of trial. I absolutely relish it. And I felt that given the fact that this defendant is looking at, you know, a second-degree murder charge, you can't go lightly.
Yeah, I mean, you know, there were many critics who said that accusing one of the witnesses of lying when it's very likely he may not remember something so well that happened 8 years ago might alienate the jury. Do you think that that's true, that maybe it could have a boomerang effect?
It could. You know, it really depends on how many witnesses they plan on pursuing, whether or not the jury will even remember that particular witness. You know, in the length of a trial, there are highs and lows, and it's a matter of what sticks with the jury. So I think that it's a dangerous tactic to continue, but within what happens, sometimes the heat of battle, it doesn't always come out the way you want. Hopefully they'll be able to salvage it as they continue on with other witnesses.
And, you know, many of our viewers may recall that Curtis Reeves initially tried to get immunity by asserting the stand your ground defense. Obviously, that didn't work. Here he is standing trial. Do you think that foreshadows how this might go, though?
That's a very good question, very interesting question. I agree with the judge's ruling that the stand your ground did not apply. And I think that it's very important to note that in most jurisdictions, you know, the self-defense argument is definitely complicated and in some places outright unavailable if it comes out that you initiated the conflict, which in my opinion is what happened here. So I think that very well could be foreshadowing of the ultimate outcome. I just feel like it's hard pressed to find jurors who will find it reasonable for someone to be shot to death over an altercation and throwing popcorn. That's a very, very difficult hill to climb.
Absolutely. Well, thank you so much for your analysis, Tamara Walker, joining us tonight. We have a lot more to come on Court TV Live. We continue our coverage of Florida versus Curtis Reeves. And then later in our Talkback segment,